All right, everybody, we're going to get started. Welcome back. My name is Emily Poor. I am a clinical teaching fellow here at the University of Baltimore in the Civil Advocacy Clinic, and I am very excited to welcome our distinguished panel for this second panel on the big idea in intimate partner violence. So our first presenter will be Professor Lee Goodmark. Professor Goodmark is the Marjorie Cook Professor of Law at the University of Maryland Francis King Carey School of Law. She's the co-director of the clinical law program at the University of Maryland and director of the Gender Violence Clinic. She's also the author of two books that have already been published: A Troubled Marriage, Domestic Violence and the Legal System, Decriminalizing Domestic Violence, A Balanced Policy Approach to Intimate Partner Violence, and the forthcoming book, which I believe is coming out in January, Imperfect Victims, Criminalized Survivors, and the Promise of Abolition, Feminism. Our second presenter will be on Zoom, Dr. Alicia Durfy, who is Professor of Sociology and Faculty Affiliate of the Women and Gender Studies and the Center of Gender-Based Violence at Arizona State University. Her work has been published in numerous journals, including Gender and Society, Violence Against Women, Feminist Criminology, and the Journal of Interpersonal Violence. She's currently working on a book manuscript titled Domestic Violence and Structural Intersectionality, the Unintended and Collateral Consequences of Victim-Friendly U.S. Law and Policy. Our third panelist, who is here on the dais, is Professor Elizabeth Isaacs. Professor Isaacs is visiting assistant professor at Brooklyn Law School and co-teaches the Criminal Defense and Advocacy Clinic at Brooklyn Law. The clinic works with survivors of domestic violence who are currently incarcerated in New York State prisons, focusing on resentencing and other post-conviction work. Professor Isaacs is also a training and policy fellow with the Survivors Justice Project. And before joining Brooklyn Law, she was a post-conviction public defender and supervising attorney with the Legal Aid Society of New York City. Our final panelist is Professor Natalie Nanasi, who is Associate Professor of Law at Southern Methodist University Dedman School of Law. She's the director of SMU's Judge Elmo B. Hunter Legal Center for Victims of Crimes Against Women. Her scholarship has been published in numerous journals and law reviews, including the Ohio State Law Review, Yale Journal of Law and Feminism, and Harvard Law and Policy Review. And she was previously practitioner in residence and director of the Domestic Violence Clinic at the American University Washington College of Law. I only have time to go over the briefest highlights of our panelists' accomplishments, so I encourage you to check out their full bios, which are on the conference website. So we'll get started with our first panelist, Professor Goodmark.
Good morning, everybody. It is a pleasure to be back at UB. I look out at all of you and all I can think about is the fight that I had with the people who built this building about whether those seats should be Kermit the Frog green. The fact that they are red is the only victory I had in the entire building of this place. So enjoy the red seats. My thanks particularly to the Center on Applied Feminism and to my very, very dear and wonderful friends, Michelle Gilman and Margaret Johnson, who are unbelievably wonderful people. And the reason that I almost didn't leave UB 8 years ago. I'm going to talk today about ideas from two of the books that you already heard mentioned, particularly my new book, the name of which I just forgot, Imperfect Victims, Criminalized Survivors and the Promise of Abolition, Feminism. And I want to say a thank you to my editor, Maura Rossner, who is here today. Maura has edited my last two books, and she is amazing. And anybody who is interested in thinking about writing, please ask me and I will introduce you to her. You would be lucky to get to work with her. So this conference is about the big idea. So here's my big idea. If we truly care about survivors of gender-based violence, we should all be abolitionists. Abolition feminism is the politics and the practice that can get us there. So like all law professors, I have three reasons why this is true. First, because criminalizing gender-based violence has neither decreased nor deterred gender-based violence. Criminalization is not working. I will just refer you to Decriminalizing Domestic Violence, where I make that argument at great length and note that yes, while gender-based violence has decreased in the years since, for example, the passage of the Violence Against Women Act, so has the entire crime rate. And the whole crime rate has decreased while we weren't throwing billions, literally billions of dollars at it. So we tell survivors, criminalization is what you need. Criminalization will help you. and we are selling survivors a false sense of security. We are lying to them about the impact of engaging with the criminal legal system. If we were abolitionists, we would be using that funding and that energy in very different ways. The second reason that we should be abolitionists is because the criminal legal system punishes survivors of violence every single day and in a myriad of ways. And that's where I want to spend the bulk of my time today. So the criminal legal system punishes young people. 11-year-old Danielle Best was raped twice in 1 month by the same man, and her parents called the Washington, D.C. police. But the police said that Danielle had purposely told a number of inconsistent stories and concluded it became apparent that the complainant was determined to get any story across that she could, regardless of how incredible it sounds. Officers closed the sexual assault case and instead requested a warrant for Danielle's arrest, charging her with filing a false police report. In internal emails, police characterized the sex that had happened between Danielle and these much older men as consensual and blamed Danielle's promiscuous behavior for her victimization. Because her parents were worried about the toll that a trial would take on her, Danielle entered an Alford plea, maintaining her innocence while conceding that the state had sufficient evidence to convict her, and she became a ward of the court. Danielle's father recalls, she said, "Daddy, I got raped and I got locked up." The criminal legal system punishes victims when they come forward as victims. So in 2017, Cassandra Jackson sought a civil protection order, protecting her from her partner's abuse. When that order was denied, Jackson hit a sign on the wall. Magistrate Michael Bachman ordered her incarcerated for 5 days for contempt of court as a result of her belligerence. In 2018, Jackson returned to that same court to seek another order. When she was told that it was too late in the day for her to go forward, she began pleading with a man in the hallway for assistance. Magistrate Bachman left his courtroom, came down the hall, chased Jackson, grabbed her, and directed her to his courtroom, where he again found her in contempt and sentenced her to 10 days imprisonment, again, as a result of her belligerence. You will not be surprised to hear that Ms. Jackson was a Black woman. The criminal legal system punishes victims when they come forward as witnesses. Over a dozen victims of intimate partner violence in Washington County, Tennessee, were jailed after they declined to participate in prosecution of their partners. Prosecutor Tony Clark defended the policy, saying that prosecutors needed to send a message. Clark said, "I'm not going to go back and apologize for what we've done because I think we were doing the right thing. At some point in time, where do we draw the line in saying that we're just going to dismiss these cases if a victim doesn't appear?" Donna Oliver was one of those people. She described how she was grabbed by both male and female guards during her incarceration. She was thrown down, sprayed, had every ounce of clothing taken from me, even my glasses. My knees were badly bruised. You could see the marks all over my legs. Correctional officers concurred that they had used both force and chemical spray against Oliver. And notwithstanding Oliver's claims, Clark said, "The arrest is not harmful. Do I think that we're re-victimizing victims? No, I don't." Victims of violence are criminalized when they commit crimes related to their own victimization. When they use force against a partner for whatever reason, most often in self-defense, when they commit crimes at the direction of or out of fear of their partners. A survey of incarcerated women in Oklahoma found that over 80% of women whose husbands were over 80% of women whose husbands were involved in their crimes, and more than 75% of those whose boyfriends were involved in their crimes had been abused by those partners. People are also held accountable for crimes committed by others, including failure to protect. 22-year-old Kelly Savage was charged with first-degree murder for aiding and abetting her husband, Mark Savage, in the death of her 4-year-old son, Justin. The charge was based on Ms. Savage's decision to leave Justin at home with his father while she ran errands. Those errands were part of a safety plan Ms. Savage had developed with a domestic violence hotline. She had plans to board a bus and leave her husband the next day. At her trial, prosecutors called Ms. Savage's first husband, Michael Alvarado, as a witness. He testified that he too had abused Ms. Savage, but that she was strong. And the jury laughed when Mr. Alvarado described slapping Ms. Savage upside her head. Prosecutors argued that Ms. Savage had caused her own abuse, manipulating the men in her life into repeatedly beating and raping her. Because Ms. Savage did not leave or call the police in response to Mr. Savage's abuse, prosecutors contended she had directly aided and abetted Mr. Savage in Justin's death. And the survivors continue to be punished with incarceration and in the clemency process, as you'll hear Elizabeth describe in just a moment. And it's not just in the context of intimate partner violence. I want to give a shout out to my friend Kate Mogilescu, with whom I co-founded. Is that a fair statement, Kate? We co-founded. Kate founded. I, rode her coattails. The Human Trafficking Clemency Initiative, where we work with survivors of trafficking who have been criminalized for crimes directly related to their own trafficking. So it's not just in the context of intimate partner violence. It is across the context of gender-based violence that we are seeing the criminalization of survivors. At every step in the criminal legal system, survivors are being hurt. They are being arrested. They are being prosecuted. They are being convicted, and they are being incarcerated. So what do we do about that? That's how we get to step 3. The third reason why we should all be abolitionists is because abolition, as Mariame Kaba would say, is how we free us from this problem. So what does that look like? People are scared of the word abolition. They think that it means chaos. They think that it means anarchy. But really what it means is change and building and growth. So for some people, the answer to this problem that I've described is reform. To fix the parts of the system, the criminal legal system, that are harming victims of violence while leaving the apparatus of state punishment intact. But reforms are not going to prevent the punishment of survivors of gender-based violence. Reforms largely center on fixing the carceral system. They're things like diversion programs, or adding new defenses, or amending sentencing laws, or improving the conditions of confinement. They use words like gender-informed or trauma-informed. All of these reforms are well-intentioned. And some do respond to very real problems in the criminal legal system. But because they largely accept the intervention of that system as a given, they have the potential to do serious harm and to preempt the kind of change that we need to prevent survivors from being criminalized in the first instance. Most of these reforms rely on actors within the system to use their discretion to do better. But these actors misuse that discretion all the time. Discretion is what enables police and prosecutors and courts and chief executives to rely on victim stereotypes to dismiss the victimization claims of criminalized survivors. Discretion is what allows law enforcement to blame victims who fail to turn to the criminal legal system for assistance. Discretion is what creates space for judgments about the failure to leave, or the failure to call police, or the failure to assist in prosecution. And what that means is that a victim's story is not credible. Discretion masks implicit bias and outright racism in how police, prosecutors, and executive powers are exercised. And most reforms don't focus on the kinds of structural conditions that bring survivors into the system in the first instance. I've said before, the anti-violence movement needs to be an anti-poverty movement. It needs to be an anti-racism movement. And these reforms don't tackle those bigger issues. Leaving the basic structure of the criminal legal system intact legitimates that system and preempts more radical change. So for example, Elizabeth's going to talk about the Domestic Violence Survivors Justice Act in New York. I like the Domestic Violence Survivors Justice Act because it helps us get people out of prison, but we need to be clear that that act does not say that punishing survivors is illegitimate. It does not say that survival is an absolute defense to criminalization. And here I'm quoting from Survived and Punished New York. By sending the message that domestic violence as a cause of criminalized conduct justifies only less punishment and not something else altogether, like providing resources and emotional or psychological support, the DVSJA implicitly validates the criminal legal system. Abolition feminism is the only politics in practice that is going to prevent the punishment of survivors. So what is abolition feminism? Alison Phipps defines it as a feminism that opposes rather than legitimates oppressive state systems. And several notable abolitionists, including Mariame Kaba and Beth Ritchie, came to abolition through their work in the anti-violence movement. They saw the damage that had been done by an anti-violence movement that colluded with the state to build repressive systems to police and punish gender-based violence. They questioned how those systems that regularly did violence to women and to queer and trans people, especially Black, Indigenous, and other people of color, was ever going to keep people safe. So to prevent the criminalization of survivors, we have to defund the structures that drive criminalization. We need to take the almost $200 billion that is annually spent on policing and incarceration and put it elsewhere into making sure that everyone has what they need to live. Housing, employment with a living wage, physical and mental health care, safe quality childcare, transportation. But we also need to be doing things along the way to that. We got to free as many people as possible. That's what the DVSJA does. That's what other mechanisms that we're using do. We've got to oppose new criminal laws that expand the reach of the carceral state, like laws criminalizing coercive control in the context of intimate partner violence. We need to repeal laws that are disproportionately bringing criminalized survivors into the system, mandatory arrest laws, felony murder laws. And we need to get rid of the mandatory minimum sentences that keep them there for disproportionately long periods of time. We need to support pretrial reform. The fight that's going on in New York right now about rescinding changes to the bail laws is our fight. We need to be involved in survivor defense, which has all kinds of different facets and requires us as lawyers to work with our community to be effective. We need to be focused on clemency reform. We need to close jails and prisons, and we don't ever need to believe that a prison facility can be gender responsive or trauma informed. Trauma inducing institutions cannot be trauma informed. We need to offer alternatives to the carceral system that identify and support non-carceral first responders. We need to develop accountability processes that take harm seriously without needing the intervention of the criminal legal system. And here's the biggest part of the big idea. We have to embrace abolition for everyone, not just criminalized survivors. As the abolitionist Ruth Wilson Gilmore explains, arguing that one group of people, for example, criminalized survivors, don't belong in the carceral system establishes as hard fact that some people should be in cages. And it does so by distinguishing degrees of innocence such that there are people inevitably who will become permanently not innocent, no matter what they say or do. There are not deserving and undeserving incarcerated people, because I have to tell you, having done work with people in prisons now for almost 8 years, I haven't met one who's not a criminalized survivor. Almost everyone in that system has experienced trauma in some way. Dr. Angela Davis has long argued that those who work to end gender-based violence should be on the front line of abolitionist struggle. Abolition is a big ask, particularly for an anti-violence movement that was founded in the belief that carceral punishment would save lives and hold those who did harm accountable. Working towards abolition is going to take a sustained effort over a long period of time, and change may be difficult to see in the short term. But preventing criminalized survivors and others from being harmed by the criminal legal system justifies that work. The only way to ensure that criminalized survivors are no longer punished by the criminal legal system is to eliminate that system. We created the carceral system. We can dismantle it and build something healing and liberatory in its place.
Thank you so much, Lee. Our next panelist is Dr. Alicia Durfy, who is joining us on Zoom and should be able to share her screen. Dr. Durfy, let me know if you have any difficulty.
Good morning. Can you hear me fine?
Yes.
Yes, I am in Arizona where it is 7:53. I apologize for the light. I tested it this morning when you guys started, and so I'm glad to just share the screen. So it says host disabled participant screen sharing.
Just a moment.
Thank you. Should I get started on the talk while you're working on that?
Yeah, okay, we can switch up the order and we will go to Elizabeth Isaacs and come back to Alicia. I apologize.
Thank you.
Oh, or it's being fixed now. Let's see.
I have disabled participant screen sharing.
Alicia, can you share your screen? I'm being told that you should request to share your screen. Let's see.
All I'm seeing when I click on shared screen is hosted disabled participant screen sharing.
We make her co-host. Okay, you've just been made a co-host.
Thank you.
Excellent. Yes, can you please, there we go. Perfect.
Okay, terrific. Well, good morning. Thank you so much. I really appreciate the opportunity to present at this conference today. I'm excited to be part of the panel, and my goodness, that's a heck of a talk to follow. So thank you all. I'm going to take a slightly different tact here as a social scientist. So I'm a professor of sociology at Arizona State University, and what I would like to do is talk about how we conduct and research on and analyze domestic violence policy and law, because I think the ways in which we've done so far has really done a disservice and has led to increasing inequality and the replication of inequality through current domestic violence policy. So I would argue that the most important structural framework that we use right now, the theoretical framework, is structural intersectionality. I came to this conclusion after seeing the increase in the use of intersectionality in social science research. And it's been heavily critiqued. It's been critiqued as the research that invokes intersectionality often has been whitened. It often signals individuals' commitment to certain norms and diversity, and rather than perhaps a true engagement with theory. And none of these are my ideas. I'm happy to refer you to a paper where I'm greatly indebted to many Latinx, Chicana, Black, Indigenous, and other individuals, both intellectuals and activists, whose ideas I'm relying on here. So for me, when we're looking at protection orders or any other form of domestic violence policy, what is important to understand is the institutional structure that seemingly neutral practices have very different impacts on individuals by their multiple grounds of identity. And what the problem is that we have a system that appears to be victim friendly, but is in fact reproducing broader social inequalities and leading to what Professor Goodmark just spoke of as the criminalization of many survivors. And the ways in which this happens is that we have, and this is according to Professor Kimberly Crenshaw, unrealistic as institutional expectations. And what they are is they're based on inappropriate non-intersectional context. So what's happening is that there's a gap. There's a gap between what we see as the ideal victim, which of course comes out of a historical context in which criminalization is the preferred approach to addressing domestic violence. And when we have that idealized victim who is white and middle class and physically abused and cisgendered and who is comfortable calling the police and for whom the police will respond and who will not arrest themselves, then when a survivor who does not fit those does not meet those norms, does not have those resources and so forth, then that mismatch leads them to be treated very differently in the system. But we only see this if we take a structural intersectional approach. And we need to look at both formal and informal policies and procedures. So when we look at structural intersectionality as a method rather than as just a theory, there are a couple different things that we need to do when conducting research. First of all, we need to, and this comes directly out of Beth Ritchie and many other people's work, is to center multiply marginalized survivors. Most research right now, if you look at it, even down to the tables they produce, are comparing other groups of people to white women. So we need to center the experiences of multiply marginalized survivors in everything from research design, coding, question, up to the choice of theoretical frameworks and how we analyze and discuss and implement policy. We need to also engage with interdisciplinarity using multi-level models. So we need to look not just at individual experiences, which are critically important, but we need to be analyzing systems and inequalities on larger levels as well. And we need to use multiple methods, both qualitative, quantitative, and mixed methods. We need to use that historical lens that Professor Goodmark was talking about to contextualize inequality. If we do research at a single point in time, what happens is we lose the meaning. We lose where these institutions that seem natural, that seem victim friendly, where they came from and where they end up sending people. We need to avoid and interrogate ideological constructions about victims, right? So often we'll rely on groups that don't necessarily actually exist. So Bakazin and Zambrana have critiqued the idea that there is in fact such a thing as a Latina survivor, right? That this is a social construction. And so that means we need to stop and think about how are we even conceptualizing groups of survivors? We need to analyze overlapping institutions because people who are navigating these systems don't just navigate one system. We can't just look at protection orders. We can't just look at mandatory arrest policies. We can't even just look at different social services. All of these are intertwined. People who are going through these things are experiencing them simultaneously. And I'll speak about that a little bit more, but looking at protection orders in isolation as if it's separate from the criminal legal system is a critical mistake and enables the reproduction of inequality. Finally, instead of relying only on deficit-based models, so we take a particular group of people and we look at how the system disadvantages them, we're framing them as that something is wrong with them, that they are not able to use what is a victim-friendly system. And it's done in almost a benevolent, privileged way, which makes it almost this insidiously neutral thing, right? So we're going to identify this particular group and figure out how we can amend different parts of the system in order to help them be able to better use it, rather than framing the system as problematic and centering the needs of those individuals. So that also means we need to, instead of only looking at deficits, examine people's privilege and agency and ability to resist, because often those aren't remarked on. We're only talking about the problems that people have and not the creative solutions that they're engaging in when they're confronting these structures and having these unequal outcomes. So in my work, I try to employ a structural intersectional perspective to look at the access of survivors to these resources, the use of these resources, and then the consequences of using legal resources for domestic violence. I focus on protection orders and mandatory arrests exclusively in the United States, but it's currently being replicated abroad very quickly. If you look at, there's a United Nations report that actually recommends a highly problematic US system kind of wholeheartedly without talking about the flaws that we're uncovering in our own system. What happens then is what appears to be a victim-friendly or neutral system ends up further subordinating already multiply marginalized survivors. And when we further subordinate them, we increase their vulnerability to violence, both interpersonal violence and state violence, and we impede their ability to be safe. So what I would argue, the big idea for me here is that we need to be thinking about how we analyze things if we're going to be, quote unquote, doing intersectionality and doing structural intersectionality. So currently how it's done is you'll pick, and in the US often it's race, class, and gender. But let's say I pick a group of immigrants, Latina, poor survivors in the greater Phoenix area, right? So I choose this very specific group, and essentially I've essentialized a group already. I've assumed that there's a homogeneity among that group, and then I study their experiences. And from that, I then suggest and evaluate interventions and modifications and resources, but none of those things challenge this overall system. And unsurprisingly, what I set out to find by looking at that group of people, I then find, so I've presupposed my findings before I even start. So I would argue that we need to invert this process. So first we need to, and again, through centering the experiences of multiply marginalized survivors, ideally with qualitative research, but not necessarily. First, we need to identify the mechanisms by which broader inequalities are reproduced. And it's going to be so tempting when you do that to say, to start putting people in categories and putting people in groups. But first, if you identify the mechanisms and the ways in which they're reproduced, then you trace those back to constellations of social identities or axes of structural inequalities, right? You trace that back, and what you find is that different quote unquote groups that we identified before, actually there are differences within the group, and then there are actually large similarities between the groups. And what that does, it allows for a changing of a system. And it also allows for greater coalition building among groups that wouldn't necessarily have seen shared interests before. So the hard thing about domestic violence protection orders is because so many people who file for orders obtain them, a lot of the barriers and problems within are obscured sheerly by that fact. Right? And so what we need to be doing is contrasting the assumptions that are embedded in formal and informal policies and contrasting that with the lived experiences of multiply marginalized survivors. So what we need to do is look at non-intersectional assumptions. And what that means is we have this kind of idealized universal victim that doesn't take into account people's differences in their experiences of violence and their experiences with the criminal legal system and other types of experiences, the resources that they have, ability to document the violence, ability to engage with the system, ability to enforce orders, their goals. And I've put a box around that because some of the slides today that I'm going to present deal with specifically with that issue. The motivations that they have for coming to the legal system and engaging with the legal system, the vulnerabilities that they face, because many survivors, when they engage with these systems, they could end up in deportation if they're in mixed status families, as we see a lot of here. Their other family members, when they call the police, can end up being deported. They can be reported to ICE, they can be reported to CPS. They get tangled up in a lot of different systems. And then also the needs that they have, right? So the need that the protection order system is seeing is that the person who is the respondent needs to be punished if there is further contact. And actually survivors are reporting that they have a host of needs that aren't being addressed through protection orders. Finally, what's important is I think that we start recognizing how the civil and criminal legal systems are not separate in domestic violence work, that they are in fact intertwined. And they become intertwined because orders are enforced through the criminal legal system. So if one chooses to file for a civil protection order, there's no way to enforce that without engaging with the criminal legal system or even having that served. So the significance of historical context, Professor Goodmark has already spoken to a lot of this, but essentially the criminalization of domestic violence was seen as a victory, and this idea of the universal woman and the survivor has really driven policy and a greater use of and referral to what used to be outside independent resources. VAWA has shifted that money into police and prosecutor advocates, with a lot of implications about who is able to use then those types of resources. So for example, I spoke to one judge about the goals that they had, what they saw the goal of the protection order is. And so the judge said, I see them as a sort of a way for a petitioner to create a boundary between herself or himself and the defendant, a way of protecting themselves, right? Another judge said the police act much quicker. It's more of an effect on police behavior than it is on a respondent's behavior. The last one I want to show you is that orders affect accountability so that we can hold them accountable. So what you see with this is actually they see the goal of protection orders as an entryway into the criminal legal system. The focus here isn't on the survivor. The focus isn't on what the survivor wants or needs. They may not want to be separated from that person. They in fact want safety, but instead they're focusing on accountability and ultimately incarceration of that respondent should they not follow the order. In contrast, if you speak to petitioners, this petitioner said, I would have liked to have an order of protection light, essentially a civil stay away order. I think that would have been effective enough in my situation. So the engagement with the criminal legal system, many of the benefits that are associated with the protection order, according to the judges and the police officers, aren't in fact what the petitioner wants at all. This petitioner said it had already gone too far to say no. Maybe the police made me file for an order. She said she at the time wanted him arrested for what he had done, but she didn't see herself as wanting to go to the extreme of not being able to see the other person. So again, this is in direct contrast to separation-based policies, which assume that safety is going to come through separation, which we know is not in fact true. Another petitioner said, I wanted protection. I was scared when I went to the police department. Maybe this is what you can do. You go get an order of protection, but it wasn't really what I wanted. But I had no choice to say yes. Again, because they're so cut and dry. What is it that they're really protecting? So I think the implications of using structural intersectionality and using it in this inverted way in order to study inequalities in the protection order system is one, we need to be recentering multiply marginalized survivors. And Beth Ritchie really argues that this helps everyone, right? Because the multiply marginalized, all the problems that they are facing are things that other people are facing as well. So when you center their needs and center them in the analysis, what happens is that kind of you address the problems that are present for everyone. This inversion of the process also avoids a lot of the critiques, especially the idea that we're doing a lot of additive analysis. So we say we're doing an intersectional analysis, but then we have a section on race, and then we have a section on class, and then we have a section on gender, and it essentializes groups, right? So it reifies these social constructions that have actually been imposed ultimately by the government in the first place. And then it reveals seemingly neutral institutional inequalities rather than focusing on survivor deficiencies. So it's starting to ask questions about, what privileges are shared, who's able to exert agency, who can resist, whose efforts at resistance are relatively ineffective, who can leverage the power of these systems, and who is marginalized and even sanctioned, sometimes in very severe ways when they attempt to use these systems. Finally, what you're affecting when you use this type of inversion of structural intersectionality is that you're getting system level, not individual level change. So I see a lot of intersectional analyses and they end up with, we need to train judges, we need to train this forth, we need to do these individual level changes, we need more advocates, as if the system isn't broken. It also interrogates ideological constructions, what victims are like, what they want, what systems should be like, and in fact, whether or not we need a criminal legal system. I think some of the ideas that were brought up before are incredibly interesting. It also produces research that engages with and extends theory, and that's the big idea that goes beyond intimate partner violence or domestic violence here, is that it could be used when studying any type of organization or meso-level analysis. And finally, the most important thing that is dear to my heart is that it has importance in activism and direct action, and that we can use it to do coalition building, which is often we work against that when we are breaking up in the name of intersectionality things into increasingly small parts, as if that will help us understand how the system that is truly broken works better. Thank you very much.
Thank you so much, Dr. Durfee. Our next panelist is Professor Elizabeth Isaacs.
Good morning. Thank you so much to the Center for Applied Feminism, and it's just really great to be with all of you today. My panelists here in the first panel as well. I feel like I'm having a lot of big ideas myself, and it's all really been amazing to hear about. So thank you so much. I'm going to talk to you a little bit about today about what I think is a little bit of a zoom in and then hopefully a zoom out on some of the ideas we've been hearing about. As Professor Goodmark mentioned, I co-teach the Criminal Defense and Advocacy Clinic with Professor Kate Mogilescu at Brooklyn Law School. And the primary work that we've been doing in the past, since the passage of this law, is resentencing motions on behalf of criminalized survivors. In 2019, New York passed a pretty groundbreaking piece of legislation called the Domestic Violence Survivors Justice Act. So every one of our students has to learn to say quickly, DVSJA, DVSJA, starts to roll off the tongue. This law, it's a big deal. It's a big deal in reform for criminalized survivors, but I also think because it is really the first of its kind in the country in many ways, it's actually an opportunity to take a close look at how, in some ways, reform isn't working. At the same time, as it is important to free as many people and get as many people out of prison as possible under this legislation. So, to start, I just want to give you a little sense of what the law is, what it does. I'm going to be focusing on one aspect of it, but basically it provides the opportunity for people who are currently being prosecuted or have been prosecuted since the law's passage to seek a lower sentence at their initial sentencing if they can meet certain criteria. It also allows people who are in prison and whose offenses occurred before the passage of the law to go back to their original sentencing court and petition for a lower sentence. Again, as was mentioned, this does not undo the conviction, right? This is a mitigation statute. It, in some ways, is very small potatoes, and but it of course makes an entirely huge difference for the people who are getting out of prison under it. Part of what you have to show in this law is initially you have to show that you have a qualifying conviction, because of course there are some exclusions. You have to show that your sentence is at least 8 years, and then you have to show that you are currently incarcerated. Okay, not really disputable facts. What you also have to show before you even get into the courthouse is you have to corroborate the allegations of abuse. So, and this is my main focus for today and of my research is, what does that mean in the post-conviction context? And what are comparisons that we can look to understand the lived experience for people who are going through this process? And I really come to this from a background in post-conviction defense, where I was litigating a lot of cases for people who I think we could all say were criminalized survivors, perhaps not of the type of domestic violence that this law addresses, but they were bringing all sorts of claims: ineffective assistance of trial counsel, failure to adequately investigate, a fraudulently obtained plea, lots of things you can say, right? Not a single one of them had to corroborate their claim before they got into court. They had a burden of proof during the actual hearing, right? There was litigation that could occur. But basically what the DVSJA does is it creates this pleading requirement that is not existent in many other forms of post-conviction relief. And so, it was kind of a head scratcher for me. I came in and I said, I don't get this. Why is this here? This isn't in other forms of post-conviction litigation. And so started to, look under the hood a little bit. And it will surprise, I think, no one here that it seems that one of the reasons this was put in here is because of the historical disbelief of women and people of color, not only in the situation of people who are criminalized survivors, but in general, in the historical rules of evidence and legal practices. So the DVSJA, ultimately what you have to prove when you get into a hearing, you have to prove your abuse. You are going to have a burden of proof, which is a preponderance for the law students here. It's a nice little refresher. So that's the burden under the statute. You're going to have to prove your abuse in court. I'll let you all think about what that could look like. The second thing is you're going to have to show some causal link. One of the things that's groundbreaking about the statute is it doesn't say causation. It's not an absolute causation standard. It's called, you have to prove that your abuse was a significant contributing factor to your criminal conduct. So it lowers that burden a little bit, right? The third thing, and this is the catch-all, talk about judicial discretion, is you could show both of those things, and then you still have to show that given all the circumstances, your original sentence was unduly harsh, right? That is the bucket that could catch, the judge could just say, you still deserve 25 to life. So is it as radical a reform as people say? I don't know. It certainly is being touted that way by the legislators that passed it. But you know, what happened in New York after it was passed is many advocates asked the prison system to kind of run some numbers and say, who's just even initially eligible? Of the people who are imprisoned in women designated facilities, how many people meet that first set of criteria? Just the ones you can't dispute, the numbers, right? And the type of conviction. And the number was 487. That's in women's facilities. It was much higher, including all the male designated facilities. But we're 3 years in, almost 3 years into the law's passage, 24 people have been resentenced under it. So you step back and you think, they added this requirement of corroboration of abuse out of this concern, this deep concern that people were going to come out of the woodwork and start claiming that they were survivors of abuse just to get out of prison. And we can leave for another day the question of whether that should be an opportunity left open to anyone who is a survivor of different kinds of abuse. But this is specifically abuse of someone in your household. It's basically, it's defined under the law. It's broader than intimate partner violence, actually. It includes, it could be a parent. It could be someone with whom you share a child, even if you don't live with them. It could be, in one case, a guardian in the sense of a group home. So there's a broadening. These are some of the good things about the law. However, the corroboration requirement is incredibly problematic. And I think that it's important to understand in terms of the intersectional analysis that Alicia Durfy and Professor Goodmark already spoke to, is that the people, who is it protecting? Who is the law characterizing as the victim that can take advantage of it? The corroboration requirement itself is pretty heavy. It requires you to come forth with 2 pieces of evidence that corroborate your abuse, one of which must be what I call either an official record or a sworn witness statement. And there are specific records that qualify: a court record, a domestic incident report, which is a type of police report in New York responding to a domestic call. It includes a hospital record, a social services record. So when we actually look how these cases are playing out, the people, the survivors who have difficulty meeting this threshold burden, again, it will surprise no one, are the very same marginalized communities who are least likely to seek help from these record-keeping institutions. And so again, the law implicitly centers the idea of a perfect victim, someone who feels comfortable reporting, someone who does not fear immigration consequences that could flow therefrom, someone who is essentially a cisgendered white middle class to upper class woman. And by doing that, the law really, as you can see with the numbers, completely misses its mark in terms of its, reformist goals. And one thing that's very difficult to measure is the chilling effect that it has on people even bringing claims. Again, this is a gatekeeping measure, right? So you can't even get into court without supplying these pieces of corroboration. And so, of course, even assuming that every survivor is aware of this as a possible avenue for relief, it's, once you hear that you have to come forward with this evidence, that's incredibly demoralizing, maybe even makes it impossible. And you do not have a right to counsel at that stage. So there's not someone necessarily advising you on how to get that. So I think when we step back from the sort of injustices of the way the law was written and think about it in comparison, I think the true motivations, whether conscious or unconscious, kind of emerge. So what I'm trying to do is create a framework where we can compare this requirement to two other contexts. One context is just simply comparing it to the other post-conviction pleading standards in New York. We have, as I said, we already have safeguards around pleading requirements for post-conviction. There's an entire statutory section around it. There's an entire body of case law dating back not only to the beginning of that statute, but to the common law writ that preceded it. And so we have an entire legal framework for analyzing who brings a plausible claim that they should be able to have the opportunity to undo their conviction or to have their sentence reconsidered. The very fact that that was in existence, but the New York legislature decided they needed to add to that gatekeeping function just for the purpose of this statute, I think says a lot. And it really, when you start to unpack the evidence law and rules that have existed for centuries in terms of who do we believe in a courtroom setting, it becomes incredibly clear the motivations here in creating a corroboration requirement. And those rules, which have been written about extensively, include the common law requirement that was codified in many states for a long time, that in order to even prosecute someone for rape, you had to corroborate the claim. It would be legally insufficient evidence to simply have testimony from the person who experienced violence. We also have the rules of competence, and that were people of color and women historically presumed incompetent to testify categorically. It was a presumption. So then there are many other requirements, including prompt outcry, including when we look at all the ways that marginalized groups have been disbelieved. So my conclusion here in looking at these two aspects, right, the sort of historical, sexist, racist constructs that have existed in law and in many ways were abolished around the time that the anti-violence movement was gaining traction, and many of these were abolished in the 70s and 80s, they're now been implicitly folded in to so-called reformist legislation. And as a result, the very people that really should be benefiting the most and are most in need of this kind of incremental reform are the people who actually can't even get inside the courthouse because they cannot meet often the threshold requirements that the statute erects as barriers. So I think that it's been so helpful to me to hear other people's research and ideas in this area, because in some ways, New York gets a lot of praise for this legislation, which rightfully so in many ways. But I do think it's also an opportunity to look not only at the limits of reform, but also the ways in which, the reform that is touted as the most impressive is also a way to make the case that none of these reforms are actually getting at the heart of the problem. Again, our front end response to how we respond to violence should not be through the criminal legal system, because the reality is that even if this gatekeeping function did not exist, we are still going to be testing the veracity of survivors in a system that prioritizes privilege in a way such as cross-examination, impeachment. These are not, let's just say, systems that we want to rely on for our truth-seeking function of the courts either. So in conclusion, I think that everyone's presentations have very much informed how I will be putting this together, and it's completely a work in progress. I very much welcome feedback, any ideas and thoughts, and thanks so much.
Thank you so much, Elizabeth. Our final presenter panelist is Professor Natalie Nanasi. I have a clicker for you. I'm not sure if your PowerPoint is up.
It's not.
Can we get
And I
Natalie's PowerPoint
I
up?
can just use the keyboard.
Okay.
Yeah. All right, thank you. Hi, everybody. It is always so wonderful to be here at this conference. It's such a fantastic place to learn, to share ideas, and as Margaret said earlier, to build community. What a joy to be back here in front of you in person, to be having these really important conversations. So thank you for having me. I'm going to be discussing a forthcoming piece I have called New Approaches to Disarming Domestic Abusers. I wanted to start recognizing I'm probably preaching to the choir a little bit here, but I wanted to do some level setting just to make sure we were all on the same page about the intersection of intimate partner violence and firearms. So just some quick, I promise, statistics for you to get us in the right frame of mind. So half of the women murdered in 2017, that's the last year for which I could find statistics, were killed by their intimate partner. Very, very dangerous to be a woman in this country. Of those murders, more than half were committed by guns. Also, probably not super surprising. Guns are deadly. Right? And we see that bearing out in the data where perpetrators are more likely to use a gun than any other means combined to murder their female intimate partners. And so we see firearms being used in about 54% of firearms, which is more than double the second most prevalent murder weapon, which is a sharp instrument, right? I mean, guns can kill very easily. They are quick, and in this country, they are very accessible. When an abuser has access to a gun, that doesn't mean he owns it, just that there is a gun available. The risk of homicide increases by 500%. That is not a typo. That is in fact 500%. And we hear experts often describing guns as the ultimate power tool in the arsenal of an abusive person. So perpetrators who own guns tend to inflict more serious abuse, even if not with that gun. We have approximately 4.5 million American women who've reported that their intimate partner has threatened them with a gun. And you can think about how you might not even need to use, to shoot, to even touch that gun to have it be threatening. I always use the example of somebody who sleeps with a loaded gun right on their bedside table, right? They don't need to touch that gun. They don't need to point that gun. Just the presence of it there is an implicit threat, and it is one that is used very, very frequently in our country. So these are very sobering statistics. This is a very sobering reality for a lot of people in this country. And lawmakers have stepped in to try to do something about this problem. So let me baseline some of the law for you, right? There's a huge category of prohibited possessors in this country. All felons If you have a felony, you are not allowed to possess a firearm. Anybody who is subject to a family violence protective order, right? So you heard earlier about protective orders. If there's a protective order in place during the duration of that protective order, you're not permitted to possess a firearm. And then in 2018, there was an amendment, and that one I should have said was enacted under the Violence Against Women Act in '94. In 2018, we expanded that to include anybody with a domestic violence misdemeanor conviction, right? This is federal law. I should say states are all over the map, pun very much intended there, on whether or not they have related statutes, related prohibitions. It's about half of the states, I would say, that have something that roughly more or less mirrors what federal law does. Surprisingly, in my home state of Texas, we actually have all three of these. Again, they're not exactly the same as federal law, but they are close enough. I should also just say these laws are not perfect. Many of you may have heard about the boyfriend loophole, which exists in the protective order context, where you have to prove that you have a shared child in common, or that you've lived together, or you're married. And so if in the boyfriend context, these prohibitions don't attach. There are a lot of official use exceptions as well. So if you can demonstrate that you're in the military or a police officer and you need the firearm, and again, do not have enough time to go into why that is problematic, given the data around the level of perpetration found in those spheres of employment. But they're not imperfect. But again, they are there. I'm not here to argue that we need more laws on the books to make this system work better. The problem is enforcement, right? We got the laws; they're just not being enforced. So let me talk to you a little bit about why that is. The first thing I should say is that right now, maybe this is obvious, but I should say it out loud, is that all enforcement is happening through the criminal justice system, right? You have police that are doing arresting. Now I'm being really obvious. You have judges who are issuing orders that may be issuing orders, I should say, that require guns to be seized or surrendered. And then you have police on the back end who are trying to enforce those orders. Now, when orders are issued to surrender, and that is not very often, we're finding that compliance is very low. So there was a recent report just from last year in Philadelphia that said there's a 13% compliance rate with orders to surrender or seize firearms. And that's in a place like Philadelphia, right? So you might imagine what it looks like in the rest of the country. So a lot of reasons for why this is happening, why the system as it's set up, again, very focused on the criminal justice system, is not working. I'm going to outline just a few of them for you today. So the first is that abusers are not rule followers, right? So they knew they were breaking the law when they engaged in the act that caused them to be arrested for domestic violence or to have a protective order issued. And they did that anyway, right? So why would we think it is reasonable to believe that telling them they are prohibited from possessing a firearm? And what we're seeing a lot across the country is federal prosecutors holding very fancy press conferences and saying, we will prosecute you, and doing, a few really targeted and I would say for show, kind of send a message, as we heard before, type of prosecutions. But why would we think that is going to cause somebody to relinquish a firearm, right? They know, they can read the same data and studies that I do, that the odds of them getting caught are probably pretty low. The second is something that I alluded to before, is that domestic violence crimes, as most people probably know, are violations of state law, but it's the federal prohibitions that attach. And this is especially true in those 25-ish states where there are no state laws on it, right? So there's a lot of confusion around who exactly is going to enforce it. Are we sending like the ATF into your house? Like whose responsibility is it to do enforcement of these laws? A really, really critical piece of this is that we don't have firearms registries in this country. We have no idea how many guns are out there and who has them. So a federal gun registry is prohibited by law. And there are no registries in basically the vast majority of states. I think there's, you could count them on one hand, and even some of those are limited to certain types of weapons, right? So when you have somebody who is denying possession, right? So let's say they are, a domestic violence protective order is entered against them, or they're convicted of a domestic violence crime, and the judge says, do you have a gun? And they're like, nope. The judge is like, okay. Right. There's no way to assess the veracity of that claim without some kind of centralized system, which I think, given where we are in this country, is we're unlikely to see anytime soon. Kind of a smaller piece of that is that you see insufficient coordination happening across systems. And so you don't see agents within the criminal justice system cooperating with each other, so that if somebody denies possession in the way that I suggested, they're able to say, well, actually, hold on, we have some sort of external corroborating proof, right? We had a victim advocate speak to her, and she said, oh yeah, I know he's got a safe, and in there's this gun, that gun, this other one. But that information is not getting across sufficiently so that a judge can say, well, you know, you said you don't have a gun, but we have all of this proof that you do. I'm going to go ahead and issue this order anyway. And the last piece that's also really important is that enforcement through the criminal justice system is actually very expensive and very time consuming. And so we've seen a number of jurisdictions across the country try to address this problem. There was a task force in Santa Cruz, California, that a number of different people were involved in. They went out for 9 hours. In that 9 hours, they were able to go to 6 homes and take 2 guns. There's the model for kind of this collaborative interdisciplinary task force, and way to do this is in Seattle, which is part of King County, and they have this huge program that is actually pretty successful. So they established this task force, and they went out and for 3 months did a lot of work to try to take guns away from people who weren't allowed to have them, and they got 141 guns in that 3 months, which is pretty good. The problem is that it cost $1 million to do that for 3 months. And so that is just not something that is in any way sustainable or realistic in the majority of jurisdictions. I can tell you, I've been working as part of these kind of task forces where I am, and it's hard to get any kind of movement. Okay, wow. All right, so I should say the lack of enforcement has really deadly consequences. Again, probably that's something also not surprising to you. There was an investigative report by Reveal that came out that found that over 100 people were fatally shot between 2017 and 2020 by people who, because of their previously abusive behavior, made them prohibited possessors, right? So people are dying. Many people are dying because we're not able to take these guns away. So hopefully I've convinced you that what we've got now, the reliance that we have on the criminal justice system to take these guns away is not working. And so what I argue in the paper is that new approaches are necessary. Because I have 5 minutes, and because you can all read this paper, I should have said it's forthcoming in the Villanova Law Review. You can Google it, you can find it if you're interested. You can read my in-depth examination of what public health law is, what international human rights is, although we'll get some good information later today on that. And I need to tell you nothing about anti-carceral feminism, the beauty of a well-curated and crafted panel. You've heard all about that already today. So I can launch into 3, I did 3 also, I guess I really am a law professor, common themes that have emerged as a result of looking at all of these areas and thinking through how they might inform a different way to try to keep people safe. All right, so the first is, again, won't have to do too much on this, right? Carceral approaches alone are not going to work, right? The threat of arrest, all of the things that we've talked about, that it's just not working, right? All the 3 theoretical areas that I mentioned before, what they do so nicely is that they reframe the issues from one that can be solved by incarcerating, arresting one person, towards solutions that implicate society more broadly, right? In the criminal justice system, as you know, that focus is really on that individual. It's a discrete crime against this one particular person, and the remedy is going to apply in that situation alone. What public health does, what international human rights does, and certainly what non-carceral approaches do is they reject that framing, right? They recognize that domestic violence and gun violence and the intersection of the two, they're not problems between individuals that affect those two individuals alone, but it's a problem that affects us more broadly. There are a lot of really great real world examples where this is working, where you're seeing a move away from the carceral system in the gun space. So in High Point, North Carolina, and also this group called Oakland Ceasefire, they're working on something called focused deterrence, which is kind of this dual, we're going to provide a lot of services, but as you've heard before, there's this piece to it where it's still within the criminal justice system, right? So the idea being, if you're not accepting of our generosity, if you're not accepting of our services, we're going to hang over you this prospect of arrest and incarceration. Alternatively, you see some really great programs. Two of them are Cure Violence and Advance Peace, where there's no law enforcement involvement at all, right? You're seeing people going out into areas where there are a lot of guns. Typically, these are associated with gang violence, and just offering services, employment, housing, financial assistance, education. And the thing is, these programs are working very, very well, right? So with Advanced Peace in particular, the American Public Health Association did a study, and violent crime declined by 43% and gun deaths dropped by 55% after their program started in Richmond, California, right? So there's a really great framework there in the gun violence space for organizations to look at that are trying to do this at this intersection of intimate partner violence and gun violence. Okay. The next piece is that prevention is really critical, right? The current system we have now is 100% reactive, right? The law permits us to arrest and prosecute somebody if they are found to have a gun in violation of the law. But as we're learning, by then it might be too late, right? And typically that is how these cases are coming across people's radars, is that there's now a body. And so we can't be reactive about this. Public health is wonderful in this area because prevention is at the cornerstone of so many of the successes that we've seen in the field of public health. Right? Think about vehicle safety, right? Seatbelts, child car restraints, helmet laws, things like smoking cessation. I know this is controversial, immunizations, right? I can't believe that is now controversial, but so much of public health, what public health does is uses prevention as a strategy, and we can take those and use them in the space of intimate partner violence and guns, right? So this law enforcement centric approach that we have right now, as you've heard before, doesn't address the systemic causes of violence or abuse, address structural drivers like misogyny, socioeconomic inequality, food and housing insecurity. And so public health theory shows us that if you create healthy environments and you increase economic security, those can be more effective strategies to keep people safe, right? So think about somebody who's not surrendering a firearm because they don't think that their neighborhood is safe, right? And so again, wagging our fingers at them and being like, we're going to arrest you if you don't give us that gun is not going to be effective, or as effective as actually making their neighborhood safe and being like, maybe I don't need this gun so much after all, right? Same with international human rights, right? It's this idea that this rights deficit, both social and economic, are at the root of intimate partner violence. So if we address them, we can prevent it. So again, prevention is really critical. And then the last piece is about the value of community. All three of the theoretical areas that I talk about in the paper really value this idea of community-based intervention. So international human rights turns our insular focus or domestic focus outward. Anti-carceral feminism seeks community as opposed to law enforcement solutions to intimate partner abuse. And public health teaches us that unique approaches and solutions are needed in different communities, right? So if we have programs and policies in place that work really, really well in urban communities of color, those might not be the exact ones that we need if we're trying to take guns away from rural conservative men, right? We have to have unique community-based approaches. And all three of the theoretical areas are showing us that if you have trusted groups, right, faith-based organizations, neighborhood associations, tenant councils, other community-based groups that are serving as safer and more effective alternatives to the state solutions that are out there, right? Especially when they're working to tailor what they're doing to the needs of the specific communities and situate the people that are most affected by the violence and harm of gun violence and intimate partner violence at the center of the advocacy. Those programs are working better, right? So people are going to be more likely to voluntarily surrender their firearms if they're provided with information, services, and counsel from people that they trust. So in conclusion, all these law enforcement focused efforts that we have tried so far are not working. They're not yielding meaningful results, right? We have done the finger wagging, right? And we haven't convinced people to turn their guns away or turn their guns in, and we've made survivors less safe in the process, right? We've tried to pressure them into compliance, but all the evidence suggests that providing resources, providing opportunities, and engaging in longer term efforts to prevent and change norms around both intimate partner violence and gun ownership is going to be more effective. I have more to say, but I think I will stop there because I know I'm over my time, so thank you.
Thank you so much to all of our panel. It's been just a wonderful discussion and really making clear how, our response to intimate partner violence has been centered on law enforcement and the ways in which it doesn't work and the ways in which it presupposes that the goal for every survivor is safety, and safety defined by the systems that are imposing these, restrictions on survivors. Yes. Can we change the screen to bring Alicia back up on Zoom, please? Someone is coming to bring you back up, Alicia. So at this point, we have about 10 minutes now for questions. So I'd like to open up the floor for anyone who would like to engage in this discussion. So we have 2 microphones at the front.
I need to see your name tag. Sorry. This question is for Professor Goodmark. I found your presentation really interesting, and I agree with a lot of what you said. The whole carceral piece I'm having some struggles with. Danielle Hicks Best, I'm familiar with her case. And when I look at that coming from a sexual assault investigations best practice standpoint, I look at that and I say, really, really shoddy investigation. And clearly multiple perpetrators who are repeat offenders got away with it, and they actually need to be prosecuted. And frankly, the police, in my view, need to be prosecuted for doing such a poor job. And there's quite a few cases like that where victims are charged with false reporting. Discretion you mentioned, I think that's a huge problem, and we need to get rid of it because there's all this room for race and gender bias. And Illinois has taken some steps in that direction with the Illinois Sexual Assault Incident Procedure Act, which is requiring officers to investigate every single report of sexual assault. They can't just turn somebody down because they don't believe them. But when we have perpetrators who are clearly dangerous, we just heard from Professor Nanasi that these are types of people who do not follow the rules. I'm not seeing what the alternative is to carceral punishment for somebody like Hicks Best's perpetrators, somebody like Larry Nassar. The way I'm looking at the world, I think there's some folks that need to be locked up, and I'm welcome for you to persuade me otherwise.
So thank you for the question. I think that's the central question that everyone who espouses abolition gets asked, right? And so I guess I would say a couple of things. First, it's really hard to focus on individual people to understand why an entire system is so problematic. It's very easy to say this person needs punishment and this person needs punishment and this person needs punishment, and that therefore justifies the continued operation of a system that does not work, that does not change those people. So there is an alternative hypothesis to the one I pose, which is we should just put those people away for the rest of time. And they should all stay away forever. And that would fix the problem. I think there are a couple of problems with that. One is it's unbelievably unjust and cruel. And the other is that we don't have that capacity. We already incarcerate more people than anyone in the world, letting people out. But if you think that incarceration is going to change those people's behavior in any way, I would suggest that you're wrong. And that in fact, the being incarcerated exacerbates many of the correlates of the violence that people do. It exacerbates economic stress, which is highly correlated with the perpetration of violence. It exacerbates trauma, which is highly correlated with the perpetration of violence. So the carceral system is not going to solve the problem of violence unless you're willing to just put people away for the rest of time. So that's one piece. I think the second piece has to do with a really hard notion to swallow, which is that we have to fix the system while we're using the system and do all of this stuff at the same time. It's like building a bicycle and riding it at the same time. And so what I want to know is when we start giving people the things that they need, do we still have these really horrible people? Or do we fundamentally change society in such ways that people are not using violence in those ways anymore? That we're eliminating child abuse and neglect that is highly correlated with perpetration, that we're eliminating community-based violence, which is highly correlated with perpetration, that we're taking care of the adverse childhood experiences that are highly correlated with perpetration. And we're doing that by giving people the things that they need. If we do that, then we have a clearer sense of, and if we say mental health is not a criminalizable offense, right? So that there are people whose mental health struggles lead them to perpetrate violence, and we're going to deal with that someplace other than the criminal legal system as well. And once we've sorted through all that, then we have a clearer sense of kind of who are those people left who are just bad people. You might be right that there are just bad people in the world who need to be put away. I guess having spent the last 8 years in what is considered to be a fairly decent prison as prisons go, I can't get behind the idea that anyone should live that way and that we as a society have the right to put people in those spaces. It's more than punishment. It is cruel and it is inhumane. And like I said, I work in what is considered to be a fairly decent prison as prisons go. And so for me, that is no longer a solution that is available. And it means we've got to find something else. I don't pretend that I have all of those solutions. I don't. There are amazing people who've been thinking about this a whole lot longer than I have. And I appreciate the opportunity to just say, like, I said, this is my big idea. It's not my big idea. People have been talking about abolition forever. Critical Resistance has been talking about abolition forever. Insight Women of Color Against Violence has been talking about abolition forever. These are ideas that I built on based on my experiences working with incarcerated people. But I can't believe that that's ever a just solution. So for me, one, it doesn't change anything. And two, it is inherently inhumane, which means we got to come up with something else. And so I think part of the discomfort that people have with abolition is the lack of certainty. What is that something else for those people who will still be there? And I'm okay with that now. I wasn't for a long time. And it was what kept me from being able to take that last step to abolition. So Maura and I laugh about this all the time. If you look at the end of decriminalizing domestic violence, what it says at the end is, we're not going to decriminalize domestic violence. We're just going to tinker around the edges of the system. And it really took being in prisons day in and day out for me to be able to take that next step and to be okay with that uncertainty. So I wish I could give you that answer. I can't. I don't think anybody can. But I think if we start to make the kind of change that's going to eliminate a lot of that violence, then we'll have a clearer sense of what we can do about it. And I don't think it's unpopular to say where we need to start is by giving people what they need.
Thank you so much. I think we have time for one more question if anyone.
May I add something to that?
Yes, please.
I think what's interesting about this conversation is that we're focused on ending domestic violence and we're focusing so hard on the perpetrator. So let's say you incarcerate that person. Where have you left the survivor? Are they still living in poverty? Do they still have vulnerability to the criminal legal system? Like, at what cost? Arrest and incarceration as opposed to what? The comparison category here is, do we arrest and incarcerate versus not arrest and incarcerate? But what happened if we reconceptualized it and stopped worrying about the perpetrator and started focusing on the survivor? What do you want and need to be economically independent? What do you need to decrease your vulnerability to state and interpersonal violence? Like, I guess I always see the conversation focused on that. Like, how can you account for how we will solve domestic violence by punishing the perpetrator? But why do we leave the survivor in the situation that they're in? Why, how is that just?
Yes, thank you so much. We do have time for one more brief question, if anyone has one. I don't see any hands and we're just about at time. So I want to thank our panelists so much and welcome Professor Johnson back to bring us to lunch and the keynote speaker.
Right. Well, thanks to this panel. We now invite you to go up to the 12th floor. There are glass elevators right outside these doors, but also if you go up to where the breakfast was served, point 5, there is a non-glass elevator, and just take it to 12. That's where we will have lunch and our keynote speaker, Professor Cassandra Havard Jones. See you up there.